So welcome to our interpretation class. This morning, we would like to discuss for the last time. Of course, we've discussed this already with my Lord Dennis. So I would say we are doing a bit of like a tutorial. We want to discuss repealed and retroactive legislation, and this is very important, and that is why we don't want you to forget it. So I presume that you'll be reading around since my Lord Professor Dennis discussed it with you. So I'll be asking you a question, taking for granted that this is an area that you have discussed already, although I was not in the class, but I'll be calling you because you're supposed to have read once it's been treated with you. Now, repeal and retrospectivity, very important. And you cannot learn statutory interpretation, constitutional interpretation, without appreciating it, because they strike at the very foundational pillars of our legal system, particularly in talking about legal certainty, protection of vested rights, and to some extent, legislative supremacy. I say to some extent in the sense that because of our constitutional dispensation, we don't have legislative supremacy or parliamentary sovereignty as it pertains to the United Kingdom. And that is why I say to some extent. Now, the central juridical question, which we need to concern ourselves with as far as repeal and retroactive legislation is concerned, is this. To what extent can a change in law disturb rights, obligations, and proceedings already in existence? And this is quite crucial in the sense that every now and again, laws are being made. However, transactions might have taken place, relationship must have been arranged or calibrated before a change in the law occurred. Sometimes either amendment in the law or a repeal of the law. So when things have taken place already and the law under which they took place actually gets changed, what happens to the rights, obligations, and proceedings already in existence? So this question arises in a multiple of legal scenarios. So one, where a statute is repealed. Two, where a new statute alters existing rights. And three, where litigation is pending during a change in law. And four, where criminality is sought to be imposed for past conduct. So these are the typical scenarios in which the question of to what extent can a change in law disturb rights, obligation, and proceeding already in existence actually come up. And from these scenarios, what we see is that it's not just a question of just interpretation. There's also a normative and constitutional dimension in the sense that the sub-issues that we raise, they touch upon issues of justice, fairness, and legitimacy of legal authority, as it were, in the sense that people are entitled to legal certainty and predictability, and where they have arranged their affairs, they expect that there'll be no sudden and unanticipated changes in the law. And that is why we're saying that quite apart from issues of interpretation, there's also an aspect of normativity to this whole area. So there's a need in this particular context, talking about repealed and
Yes, sir.
retrospectivity,
Yes,
to
sir.
try and then somebody is talking somewhere there.
Well,
Yeah, so there's a need to strike a delicate balance between two competing matters. First is the power of parliament, legislative supremacy, as it were. If you look at the Constitution, Article 93, 94, 106, Parliament has the power to enact laws, to amend laws, and repeal laws. So we can say that within the governance architecture, to the extent that Parliament is the arm of government, clothed with mandate to make laws, they can also change the law at any time. They can even repeal the law in ways that may even affect existing situations. So that is one. Again, as I indicated, there's also the need to have legal certainty and stability. And of course, that is one of the important hallmarks of rule of law. And don't forget that our Constitution, in the preambular statements, talk about the fact that we are trying to create or nurture a society which is anchored on important pillars like rule of law. And related to rule of law is the need for legal certainty and stability, because individuals must be able to regulate their conduct, their affairs, based on the existing law. And if they are to be able to do that, there's a need for predictability, stability, and protection of legitimate expectations, as it were. The third related issue is the doctrine that rights once accrued or vested should not be lightly disturbed. So we are talking about protection of vested rights. So once people have acquired rights or rights have accrued, it shouldn't be disturbed. And this is very central to adjudication. And as you have noted, the courts have had to make a lot of affirmation of that principle. So let us keep that in mind. And then there's a case, Newborn Till against Kanderena Bas Mara. I'm sure you came across it. Reported in the 1982 3 at page 833, where Lord Brightman made the observation that, quote, a statute is retrospective if it takes away or impairs a vested right, accrued under existing laws, or creates new obligations, or imposes a new duty, or attaches a new liability in regard to events already past. So this definition is very important, as it gives a very good description of what we are talking about as far as retrospectivity and then accrued rights are concerned. So let us keep that in mind. Now, if we look at our Constitution, We have read Article 107 over and over again, but just for the sake of emphasis, I would like one of you to read Article 107 of the Constitution for us before I proceed. Yes, so somebody should read Article 107 for us. Article 107 of the 1992 Constitution.
Article 107. Parliament shall have no power to pass any law, A, to alter the decision or judgment of any court as between the parties subject to that decision or judgment, or B, which operates retrospectively to impose any limitations on or to adversely affect the personal rights and liberties of any person, or to impose a burden, obligation, or liability on any person, except in the case of a law enacted under Articles 178 to 182 of this Constitution.
Okay, good. Yeah, so thank you very much. The Article 107 is reminding us that the issue of retrospectivity has got constitutional dimensions. And the essence of Article 107, as she read beautifully for us, is that Parliament shall not enact retrospective criminal legislation, and no person shall be punished for an act which was not an offense at the time it was committed. And again, of course, we know from your criminal law, you know the nullum crimen nulla poena sine lege, no crime, no punishment without law. That's very much related to that. And again, where the courts have made adjudication concerning the people's rights, Parliament cannot legislate to actually take away rights which have been pronounced in favor of people, as it were. So, and there's presumption against retrospectivity, and we have seen that over and over again when we discuss presumptions. And you met the case of Republic against the Judicial Secretary, ex parte Toto. Remember the case of ex parte Toto? Can anybody tell us what happened in ex parte Toto in 1979 Ghana Law Report? Yes? As I've told you, you have learned this already. So what I'm doing is essentially doing the revision with you. Yes, what happened in ex parte Toto? Okay, so if you look at the report, Republic against Judicial Secretary ex parte Toto, 1979 Ghana Law Report, page 444. The respondent was a circuit court judge who joined the judicial service before February 1971. At that time, the Judicial Service Regulation, LI 319, particularly Regulation 48 thereof, provided that, quote, a holder of judicial service post on pensionable terms shall retire from the service on reaching the age of 60 years unless the president otherwise directs, unquote. So this was the provision in the relevant law. Now, by a letter dated 26 February 1971, the government, with the sanction of the president, reduced the retiring age of all civil servants and public officers from 60 years to 55 years. And this directive was communicated to all judicial officers in the judicial service by the Judicial Secretary by a letter, and that LI 319 was not amended. Now, later on, the Judicial Secretary wrote to the respondent reminding him that, according to official records, he will reach the statutory retiring age of 55 years in October. and for that matter, he should retire from the service with effect from that date. Now, the respondent replied the letter and cited LI 319 and stated that the retiring age, according to LI 319, was 60 years. Now, on 15 September 1978, the Supreme Military Council, that the SMC, who succeeded the National Liberation Council, in exercise of power conferred by the Section 31 of the Judicial Service Act, as amended, issued another LI 1168, amending the earlier LI 319, particularly Regulation 48. Remember, LI 319 Regulation 48 had actually reduced the retiring age from 60 to 55 years. But then this new LI 1168 has come to amend that. And the amendment was made retrospective to 26 February 1971. So mind you, the new law was made on 15 September 1978, as it were, but the amendment was backdated to have effect to 26 February 1971, provided that in making such regulation relating to administration of judicial service, the Supreme Military Council should act on advice of the Judicial Service Commission, an institution which has ceased to exist since the promulgation of the 1969 Constitution, which provided instead for establishment of the Judicial Council. So, on 2nd October 1978, the respondent went to the High Court, Accra, and sought judicial review in the nature of certiorari to quash the official letters calling for his retirement, and also for another prohibiting the judicial secretary from retiring him at 55 years. Now, before the court, it was contended on his behalf that the new law, that is LI 1168, was invalid since it was apparent from the Judicial Service letter that before promulgating it, the Supreme Military Council did not act on the advice of the Judicial Council, but rather acted on the prompting of the Chief Justice. No evidence was produced to substantiate this assertion, and the trial judge, that is the High Court judge, held that if such evidence had been adduced, he would have declared LI 1168 to be void. But in absence of such evidence, LI 1168, having on the face of it been made under Section 31 of the law, in his view, satisfied the presumption of regularity, what do you know as the omnia presumintu, rete se acta. So, essentially, that was it. And he made another holding that the government circular on the new retiring age was not intended to apply to holders of judicial office. But the fact that an enactment was founded on wrong premises did not entitle the court to go behind the legislation and find out how it came to be. So he accordingly declared that LI 1168 was valid, but that Regulation 48, as amended, applied as from 26 February 1971 to affect the retiring age of officers engaged in the service since that date. So the respondent's application for certiorari was granted together with the declaration, since he had been engaged as a holder of judicial office before the date, that is before 26 February 1971. And his right to retire on compulsion on reaching the age of 60 was unaffected by LI 613 Regulation 4. That is the old law. So this was the decision of the court, and he, of course, this did not go well with the government, so they appealed, and then the matter came before the Court of Appeal, which at the time was also functioning as the Supreme Court. So essentially, if we look at the report, what is relevant to us has to do with the holding number 2, as reflected in the editor's headnote, and this is what it says: LI 319 Regulation 48, as amended by LI 1168, was clear and unambiguous, and its wording must be interpreted in its ordinary sense, free from the glosses and interpolations placed on it by the trial judge. In arriving at this interpretation, the Regulation 48(1), as amended, operated as from 26 February 1971 to affect the retiring age of officers engaged in the service since that date. The trial judge imported words and phrases into the very enactment being interpreted and invoked 2 presumptions: the one against taking away vested rights of persons, and another that a statute was not to be construed as to have greater retrospective effect than its language rendered necessary. The express words of the enactment that, quote, a holder of judicial office, judicial service post on pensionable terms otherwise than on a limited engagement shall retire from the service on reaching the age of 55 years unless the president otherwise directs, did not, according to the code, warrant the invocation of either presumption. Holders of judicial service posts falling into the responding category did not enjoy the same constitutional guarantee or entrenchment of their right in respect of retirement, privileges, and other conditions of service as their senior counterparts, the judges of the Superior Court. And the principle and enactment providing for the retirement of age of inferior court was still, according to the court, was still valid. So the point for our consumption and relevance, among other things from ex parte toto, is that no statute shall be construed to have retrospective effect unless such intention appears clearly from the terms of the act or by necessary implication. And that is very important, and no wonder Article 107 of the Constitution is even reminding us. So therefore, there's a strong interpretive presumption in favor of prospectivity, that all legislation are forward-looking. They are not backward-looking. So that's a strong presumption. And ex parte toto reinforces that for us. Can anybody tell us what happened in the British Airways against Attorney General? Since you've learned this already. Yes. What happened in British Airways against Attorney General? British Airways against Attorney General. Yes. Did you come across this case?
Good morning, my lord.
Morning.
Yes, please.
Yes.
We came across in the reading of British Airways and Attorney General.
Yes.
So in my notes, I have that the PNDCL 150, which is about the acquisition or rental of immovable property, under which the plaintiff was tried, it had been repealed, and there was no saving by an amending enactment of the specific provision under which the plaintiff was to be held guilty. So the criminal case could not continue to be prosecuted under the repeal law. So at the end, the court, what it stated that it was unconstitutional to convict any person unless there is a written law which defines the offense and provides sanction for the same.
Yeah. Yeah. So thank you very much. Yeah. Yeah. So that was another illustration of how Article 107 should be respected. So the British Service Against the Attorney General, as she rightly told us, the applicants were being prosecuted under a statute which had been repealed without a saving clause. And the Supreme Court held that the continued prosecution was unconstitutional because there was no existing law defining the offense. And British Airways Against Attorney General reinforces the point. Please make sure that your mic is always off unless you are invited to speak. So those who have their mic on, put the mic off. Thank you. So criminal liability cannot survive repeal unless expressly preserved. So if someone has been charged with an offense under a legislation which has been repealed, unless the repealing legislation have a saving clause with respect to that old legislation, automatically the criminal liability will have to, prosecution will have to come to an end. Yeah, so that is one lesson we distill from British Airways Against Attorney General. And the underlying philosophical justification for this rule is that, it's fairness. The courts have recognized consistently that it will be unjust to impose liability based on laws not enforced. It will undermine confidence in the legal system. So, anytime a person is charged with an offense or being prosecuted for an offense, the law should be enforced. If the law is not enforced, and if there's no saving clause with respect to that, then automatically it cannot go on. So, legal consequences must ordinarily flow from law as it existed at the time of the relevant act. Now we need to draw important distinction here between substantive law and procedural law, and for that matter, between substantive rights and procedural rules. Substantive rights, as we know, are rights which are protected when we are talking about retrospectivity and repeals. And procedural rules, they may change immediately. And we have made the presumption earlier when we were learning about presumption that no one has a vested right in procedure. So what it means is that, yes, your substantive right and interests are very much respected, but then you cannot insist that you like the law relating to procedure for vindicating your right to be the same all the time. No. So if there are changes in, for example, how cases are supposed to be conducted, and it doesn't matter that you started your case about 3-4 years ago, you have to follow the new, for example, arrangements that have been provided under the law, because that relates to procedure. You do not have a vested right in what? In procedure. But your substantive rights will remain unaffected. So let's keep that in mind. So let's suppose that we have like the Land Act, which was passed 2020, which has brought about certain things. For example, when it comes to this spousal property, the written consent transaction, and so on. So let's suppose that before 2020, you have done a transaction, and that transaction did not follow the requirements of the Land Act. Now, that matter has to do with the substantive right. And for that matter, the new law, the Land Act of 2020, is not going to affect it. But it will be different if, for example, there was maybe like a change in how, let's say that the land cases or certain things should be done in the course of proceedings. That one relate to procedure, and that one you have to follow the new arrangement, because it is the position of the law that no one has a vested right in what? In procedure. So let us keep that in mind. The understanding so far is that statutes are presumed to be prospective, that is forward-looking, and retrospective effect must be clearly expressed or necessarily implied. Accrued rights are protected, and accrued rights here refer to substantive rights, no procedural rights, and procedural changes apply immediately if there are changes in the law with respect to procedure. They take effect immediately, they come into force. And of course, as we have seen in terms of Article 107 and also Article 19, criminal retrospectivity is what is constitutionally prohibited. So let us keep that in mind. Now, we also need to talk about express repealed, which of course you have discussed already. And express repeal arises where a later statute explicitly declares that an earlier enactment or part of it is repealed. So that is the direct, if you like, direct repeal. So there's a legislation already in force, and later on there's another legislation which comes to do one of two things. Either it says categorically that the old or the existing legislation is repealed, in which case it's abrogated, it's cancelled, brought to an end. Or it may say that a part of it is repealed, or part of it is amended. And if you look at the practice of statutes, the typical formulation will be like this. Maybe the earlier act is hereby repealed. So maybe they'll say that, for example, in the Land Act, we'll be told that the land title registration law, in 1986, PNDC law 152 is hereby repealed. So that is, like, for example, a typical example of how express repeal may manifest. And express repeal represent the highest degree of legislative clarity, in the sense that it is quite explicit. The provision will say that this has been repealed, and that is what it says, and that is what it means. So it leaves no room for inference, speculation, or any, if you like, interpretive or reconstruction, as it were. And the courts usually treat express repeal as conclusive of legislative intent. And for that matter, for purposes of interpretation, the job or the task of the interpreter is limited to two main things. One, identifying the scope of the repeal. What is the scope of the repeal? The said repeal, what does it encapsulate? What does it encompass? And two, determine whether any saving provisions actually apply. Yeah, so these are the two things which the interpreter should concern himself or herself with as far as express repeals are concerned. Yes, Kwaku Opoku, let's hear you. Kwaku, your hand is up. Or was it by accident?
No, good morning, my lord.
Good morning.
Thank you very much for the opportunity. So, my lord, I think I have followed and I've enjoyed the discussion so far. I just have a little question.
Okay.
If I look at the case in the British Airways, the Ghana Airways and the AG,
Yes.
case of in retro too, my lord, you realize that in the case of Ghana Airways, when the law was repealed, the prosecution right was disturbed. But at the time the prosecution started, the AG had a right to prosecute because the law at the time made that act offense, an offense, criminalized that act for which the AG was prosecuting. So along the prosecution line, then the law was repealed. So I am curious as to how the law now came in on this occasion to disturb the right that was accrued to the AG. However, if we look at the case of in Retoto, you realize the court ruling was on the effective date of the new LI and did not go to disturb the accrued right of the employee.
Yes.
Yeah, so you realize there's a bit of lacuna here. I think there's a pick and choose because at some point they use the effective date because if they've passed a law now that when you jump the red light, it's not offense and there's no savings. And somebody jumped the red light maybe 3 weeks ago and the person is being prosecuted. At the time the person was being prosecuted, the police or the AG who was a prosecutor had an accrued right at the time to prosecute because the person has offended the law at the time. Okay. So regardless of a service or not, we are not using a forward-looking law, but we are using an existing law that was effective at the time the act occurred, my lord.
All right, thank you, Kwaku. You see, if we look at the British Airways against Attorney General, the relevant provisions, the Section 8(1)(e) of the then Interpretation Act 1960 CA4, which has equivalent in the Interpretation Act of 2009. And that provision was this, quote, the repeal or revocation of an enactment shall not, E, affect any investigation, legal proceeding, or remedy in respect of any such right, privilege, obligation, liability, penalty, forfeiture, or punishment, and any such investigation, legal proceeding, or remedy may be instituted, continued, or enforced, and any penalty, forfeiture, or punishment may be imposed as if the enactment had not been repealed or revoked. Now, if you look at then they also cited the Article 19, Clause 11 of the 1992 Constitution. I'm talking about what the Supreme Court used to guide it in coming to decision. And Article 19, Clause 11 of the Constitution says, and I quote, no person shall be convicted of a criminal offense unless the offense is defined and penalty for it is prescribed in written law. So this is what the law was, and the Supreme Court made the point that if you look at what really happened, that whenever in the course of it, I'm just taking the holding 2 and 3 for you. Whenever in the course of any matter before the court, it was found that there existed in any lower court any matter which would not result in injustice or illegality, it was a duty of the court to immediately intervene and issue such orders and direction that will prevent illegalities or injustice. And above Section 8 of the Criminal Code, 1960 Act 29, and Article 1911 of the Constitution, criminal offenses had to be so designated in a written law. Accordingly, in the instant case, with the repeal of PNDC Law 150, and in the absence of any written law defining an offense or providing a punishment, it would be futile for the plaintiff to go through their trial because they could neither be convicted nor punished. Furthermore, it would be a negation of the court's duty and a condonation of illegality, which, if not stopped, will result in interference with and breach of the plaintiff's right of liberty. Accordingly, in the interest of justice, the Circuit Tribunal will be ordered to discontinue the criminal trial of the plaintiff and strike it off. Then the holding 3, they added, since under Article 1911 of the Constitution, it was unconstitutional to convict or punish any person unless a written law defined or provided sanctions for the offense, the provisions of Section 8(1)(e) of the Interpretation Act dealing with the effect of repeal, revocation, or seizure of an enactment was unconstitutional. in respect of criminal offenses contained in a repeal law, such as PND's Law 150, and therefore inapplicable to the criminal case pending against the plaintiff. It would have been different if the plaintiff had been convicted before the repeal of PND's Law 150 by at 516 or if at 516 had saved offenses committed before the repeal of PND's Law 150. Since at 516 was silent on that issue and merely repealed PND's Law 150, provisions of Article 19 Clause 11 became applicable to the criminal case pending against the plaintiffs. So, Kwaku, the import of the Supreme Court decision and in relation to your question is that the Supreme Court had a problem with the provision of the Repealed Interpretation Act, CA4, this is Section 8, 1A, to the extent that it was also being applied to criminal offenses. Because the Supreme Court is making the point that if you look at Article 19, Clause 11, to the extent that the Constitution quite explicitly required that an offense should be defined in a written law with the punishment prescribed for it before a person can be convicted of sin, then if you had a situation where the enactment creating the offense had been repealed by another enactment and there was no saving clause in the repealing enactment with respect to the enactment being repealed, then you could not go ahead and continue to prosecute somebody under the repealed law, because Article 1911 will make it impossible for the person to be convicted, because it says that you must be convicted and punished for an offense which is defined in the written law with the punishment prescribed. But by the time you are going to convict the person, there's no such law. So that was the situation. So that is different from the total one. In the total one was in any case not a criminal case. So let's know the difference. Kwaku, I don't know if that assists you.
Yeah, thank you very much, my lord. I'm grateful.
Yeah, so we're making the point that where we have express repeal, then what the interpretive task is essentially to, one, identify the scope of the repeal. In other words, find out what exactly does the repeal encapsulate. Is it the entirety of that law or portion thereof? And two, to determine whether any saving provisions apply. Is there any saving provisions in the repealing act with respect to the old legislation? Now, even where the repeal is express, it does not necessarily extinguish all legal consequences arising under the repealed law. And if you look at the Section 34 of the Interpretation Act, somebody should read Section 34 of the Interpretation Act 2009 as 792 for us. Section 34.
Section 34, subsection 1. Where Section 34, effects of repeal, subsection 1. Where an enactment repeals or revokes an enactment, the repeal or revocation shall not, except as in this section otherwise provided, A, revive an enactment or a thing not in force or existing at the time at which the repeal or revocation takes effect. B, affect the previous operation of the enactment that is repealed or revoked, or anything duly done or suffered under the enactment. C, affect a right, a privilege, an obligation, or a liability acquired, accrued, or incurred under the enactment that is repealed or revoked. D, affect an offense committed against the enactment that is repealed or revoked, or a penalty or a forfeiture or a punishment incurred in respect of the offense. Or E, affect an investigation, a legal proceeding, or a remedy in respect of a right, a privilege, an obligation, a liability, a penalty, a forfeiture, or a punishment. And the investigation, legal proceeding, or remedy may be instituted, continued, or enforced, and the penalty forfeiture or punishment may be imposed as if the enactment had not been repealed or revoked. 2. Subsection 1 does not authorize the continuance in force after the repeal or revocation of an enactment or of an instrument made under that enactment. 3. Where an enactment expires, lapses, or otherwise ceases to have effect, this section shall apply as if that enactment had then been repealed or revoked. 4. The inclusion in the repealing provisions of an enactment of an express saving with respect to the repeals affected by the inclusion does not prejudice the operation of this section with respect to the effect of those repeals. Thank you, my lord.
All right, thank you. Good. So I want to ask from the class, what is your understanding of Section 34, particularly relation to the British Airways against Attorney General? Yes. What do you make of it? I told you we are doing a tutorial, so you should be ready to talk to me.
My lord.
Yes.
Okay, so Section 34, I think, is simply forbidding any authority from retrospectively applying a law that is newly introduced to repeal a particular law. So let's say, in effect, in the context of the British Airways and then the Attorney General, it's simply telling us that if a right has accrued to a person under the law before the introduction of a new law, those rights, but let me gather my thoughts again.
All right. Yeah. So put your thought together. Anybody? Yes.
My lord, I think the British Airways case, as you pointed
Yes.
out,
Who is
it's
talking?
actually, my lord, is Dolly.
All right.
Okay, to start with, Section 34 is more or less preserving whatever has accrued under the rights that have accrued in relation to the repealed law. So it's saying that the rights are not affected, and particularly it says that the repeal does not affect offenses committed against the earlier act. Legal proceedings be continued. But then when we look at the British Airways case, which is particularly in relation to criminal proceedings, we are seeing something a little more or less the opposite being done, i.e., and this is because, as you explained, looking at Article 1911 of the Constitution, it can't be that where an offense is not sort of clearly defined in a statute, that someone can be convicted of such. So it's showing the exception to some of the in relation to criminal proceedings to what has been set out in Section 34 of the Interpretation Act.
Maybe to make our this thing complete, read the Section 35 as well.
Section 35, effect of substituting enactments. Subsection 1. Where an enactment repeals or revokes and reenacts with or without modification, an enactment, a reference in any other enactment or statutory document to the enactment so repealed or revoked, shall, without prejudice to the operation of subsections 2 and 3, be construed as a reference to the enactment as reenacted. 2. Where an enactment repeals or revokes an enactment, in this subsection and in subsection 3 referred to as the old enactment, and substitutes by way of amendments, revision, or consolidation with any other enactment. A person acting under the old enactment shall continue to act as if appointed under the enactment so substituted. B. A bond or a security given by a person appointed under the old enactment remains in force, and the books, papers, and things used or made under the old enactment shall continue to be used so far as in consistent with the enactment that is substituted. C. A proceeding taken under the old enactment shall be continued under and in conformity with the enactment so substituted, so far as it may be done consistently with the substituted enactment. D. In the recovery or enforcement of penalties and forfeitures incurred, and in the enforcement of rights existing or accruing, under the old enactment, or in any other proceeding under the old enactment, the procedure established by the enactment so substituted shall be followed so far as it can be adapted. And E. Where a penalty, a forfeiture, or a punishment is reduced or mitigated by a provision of the enactment so substituted, the penalty, forfeiture, or punishment, if imposed or awarded after the repeal or revocation, shall be reduced or mitigated accordingly. 3. In addition to subsection 2, where an enactment repeals or revokes an enactment and substitutes by way of amendment, revision or consolidation another enactment. A. The instruments or statutory documents made, issued, confirmed, or granted under the old enactment, and the decisions, authorizations, directions, consents, applications, requests, or things made, issued, given, or done under the old enactment. I. Which are in force at the commencement of an enactment that is substituted. And II. Which are not inconsistent with the enactment that is substituted, shall have the like effect, and the like proceedings may be had on and in respect of the enactment as if they had been made, issued, confirmed, or granted, or made, issued, given, or done under the corresponding enactment that is substituted. And B. A reference to the old enactment in an unrepealed or unrevoked enactment shall I, in relation to a subsequent transaction, matter, or thing, be construed as a reference to so much of the enactment that is substituted as relates to the same subject matter as the old enactment. And II. If nothing in the enactment If nothing in the enactment that is substituted relates to the same subject matter, the old enactment stands good and be read and construed as unrepealed or unrevoked where it is necessary to support, maintain, or give effect to the unrepealed or unrevoked enactment.
Okay, good. Yeah, so I will urge you to take your time, read section 34 and 35 closely several times, and let it be part of the repertoire as far as the knowledge required for repealed and retroactive legislation is concerned. As you have noticed, section 34, seeks to generally preserve accrued rights, liabilities incurred, and proceedings will commence unless there's a contrary intention. And of course, this does not only ensure continuity, it also prevents injustice. So, if you look at even the 34 and the 35 closely, the overarching principle or the objective is that repeal does not destroy the past. It only changes the future, as it were. So a repeal law continues to govern past acts, rights, liabilities, and proceedings, unless the legislature clearly provides otherwise, as it were. And that is why section 34(1) is telling us what a repeal is not. And that's very important. So repeal of a repealing statute does not revive earlier law unless expressly stated. So for example, if we have, let's say that a particular legislation, let's say law A, is repealed by another legislation, let's say law B, and law B, which was repealed, which repealed A, for example, is later repealed, okay, by, let's say, C. The fact that law B, which repealed law A, has subsequently been repealed does not automatically means that law A has come back. So let's keep that in mind. So for example, let's suppose that we have a law in 1990, okay, which regulates banks, and in 2000, a law is passed to repeal the 1990 law. And let's suppose that in 2015, a new law is passed, and that new law repeals the 2000 law. What we are being told by effect of section 34 and 35 is that the 1990 law does not revive automatically by reason of the fact that the law which repealed it had this will be repealed, unless it is expressly provided. Otherwise, there's no automatic reviver, as it were. We discuss this aspect again. And again, we are told that repeal does not affect what has already been done under the law. And that is why it says that anything duly done or suffered under the enactment is not affected. So all things, all acts which were done while the law was valid remain valid, and they remain legally effective. So for example, if a license has been issued under a law which has been repealed, that license will continue to be valid. It will not be that, oh, because that law has been repealed, then the license issued has also been repealed. No, it doesn't work that way. In the same vein, if a tax has been paid and a repealed law is still valid, you cannot go and say that you are going to claim your tax which has been paid and so on. So the law, in a sense, does not undo what was lawfully done. What was lawfully done remains. And in the same vein, if you look at it, the 34 closely, the repeal does not affect rights or obligations already acquired. What does that mean? So, rights, for example, your entitlement under contract. If you have no entitlement under contract, or even maybe like you have a right by reason of some tortious arrangement, as it were, or some privileges or obligations or liabilities, the repeal will not affect it. So, for example, if a person had a pension right under law, and the law is repealed, the pensions right remains not enforceable because the right have been accrued. An accrued right, as we have noted, is protected. It's different from mere expectation. That is what you are yet to get. That one is not protected. So, for example, if there was a law on pension, and if you had brought yourself within conditions set under that law, you have enjoyed certain privileges. But then the law was repealed at the time that you had not yet met the conditions under that law. Subsequently, when you meet the condition, you cannot say that because I have met the conditions under that law which are repealed, I'm still entitled to it. No, your right had not accrued. Your right had not crystallized before the repeal took place. So let's keep that in mind. And as we have seen the U-Bond 2 against the Kandaran and Basmara case, that it is only vested rights which are protected and not things that you expect. And again, when it comes to offenses and penalties, repeal does not affect offenses already committed or penalties incurred. And let's pay attention. We are talking about where a person has actually been convicted of an offense, and then the law is later repealed. The repeal will not affect it, or the penalty incurred, as it were. So if a crime was committed before repeal, the person can still be what? Can be prosecuted. We are dealing with things which occurred at the time. So at the time that the act was done, was it a crime? If it was a crime, then it is a crime. But so let's suppose that someone stole something or committed a crime under old law, and then the law is repealed. Can prosecution continue? Can prosecution continue? Remember British Airways against Attorney General?
Yes, my lord.
So what will be the position?
So, if there, assume there was no in the Article 1911 provision, once the prosecution started from the previous enactment, that's the repeal one, even if there's no any service, the prosecution will continue with the old law.
Okay. But in British Airways, there was no saving clause.
Because of Article 1911, that was the reason why they couldn't continue. But because if you look at the civil cases, whether there's savings or there's no savings, the person will continue to be prosecuted with the old law. Unlike the criminal, the difference is that with the criminal, the difference is Article 1911.
Okay. Good. If you look at the section 34.2, which you read for us, if we look at section 34.2, that the subsection 1 does not authorize the continuance in force after a repeal or revocation of an enactment of an instrument made under that enactment, as it were. So we are talking about limitation. Repeal does not keep the law alive going forward. That is to say that the law cannot be used for future actions. Only past matters are preserved. So if old law is repealed, it cannot regulate things which happen after the repeal. It can only apply to past events under appropriate circumstances, as we have been considering. Now, what about 34.3? What is the import of section 34.3? What is the true import of section 34.3? Yes? You've learned this already. So, yes, 34.3. What is the true import? Are we together? So since this was discussed in class with you, you've never really studied it again, eh? As far as I'm concerned, my Lord Dennis did this with you more than a month ago. So, for example, in terms of section 34.3, if supposing a law expires, maybe by reason of its duration or circumstances, or the law lapses, it will be treated as if it's repealed. And the same rules apply whether the law is repealed or simply expires. Because in that case, they have like the same or the effect. Now, what about section 34.4? What does it tell us? So if you have a legislation which has a saving clause, what will be the effect of that? And in relation to section 34, will it mean section 34 will not apply because that legislation has a savings clause?
No, please, my lord. This is Dolly, because the subsection 4 says it does not prejudice the operation of section 34.
So what does that mean?
It doesn't apply. So the provisions of section 34 will continue to apply, such that as we've explained, such that the repeal, the new act will not, unless otherwise provided, affect the rights accrued under the previous act. So those provisions will continue to apply, even where, or whether or not even where there's a savings provision.
All right. Okay. Thank you. Yeah. Then section 35, dealing with the continuity when the law is replaced. So where the law is repealed, and replace. References to the old law will now refer to the new law. So let us keep that in mind. And again, continuity of official actions. So people enacting under the old law will continue under the new law. Let me give you an example. Let's suppose the appointments were made under a law which has been replaced, as it were. It will not affect those who were appointed. They will continue to remain, have a valid appointment. The same thing applies to the license, as we illustrated, that where licenses have been issued under an old law and the law has been repealed, it will not affect validity of the license, as it were. In the same vein, when it comes to proceedings under old law will continue under the new law, because we've noted that there's no vested right in procedure. So let us keep that in mind. What about penalties? If the new law reduces a punishment, then the reduced penalty applies. So here, despite the fact that it's not procedure, this is substantive, because punishment is not a procedure, it's a matter of substance. But if, for example, old law, the punishment was, let's say, 10 years, and then the new law says 5 years, the court will not apply the old law imposing 10 years. It will have to apply the new law imposing 5 years. And again, if you have like subsidiary or subordinate legislation, delegated legislation, such as LI, bylaws, and so on, under the repealed law, they will continue to have effect. They will continue to have effect, even if there's no express provision in the new law saying that the instruments made thereunder are supposed to remain in force. Because of Section 34 and Section 35, they will still continue to have effect. So let's keep that in mind. So when let's suppose that exams, you get a question, you always have to ask yourself, are there accrued rights? Are proceedings pending? Is there a saving provision? Is it the criminal or civil? These are very important. And I'll say a few more things before we end the class regarding how you should answer questions. Then we also have implied repeal. Implied repeal arises where a later statute does not expressly repeal an earlier one, but the provision of the two statutes are so inconsistent or repugnant that they cannot stand together, in which case we say that there has been an implied repeal. So there's no explicit mention in the new law that it is repealing an existing or the old law, but then you consider provisions of, let's say, the old and then the new, and you see so much inconsistency and repugnance that the two cannot stand together. One must necessarily be taken to have repealed the other. So in circumstances like that, the later statute prevails to the extent of the inconsistency, and that will be considered as implied repeal. And that is why we met this expression when we were doing the presumption that leges posteriores, priores contrarias abrogant. That is to say that later laws abrogate earlier inconsistent laws. So what are the conditions for implied repeal? For implied repeal to arise, the inconsistency must be 1, clear and irreconcilable. 2, the inconsistency must not be capable of reasonable interpretation. And 3, the inconsistency must be such that both statutes cannot operate concurrently. There's no way the old and then the new law can continue to operate meaningfully because of the inconsistency. But mind you, mere overlap or tension is insufficient. It should be that which meet the threshold we're talking about. Is the inconsistency reconcilable? If we do some reasonable interpretation, can't we cure the supposed inconsistency? And then, is it said that if the two are continued to operate concurrently, it will not make sense. It will not be effective. Now, when you have met that threshold, then that is a clear case for implied repeal doctrine to operate. So, but of course, courts are very careful when it comes to using the implied repeal doctrine. And implied repeal is disfavored, meaning that the court will not rush to fair repeal unless compelled to do so. So let us keep that in mind. And the dominant judicial approach is for harmonization. What does that mean? That is to say that instead of rushing to deploy implied repeal doctrine, the court would like to rather read the statutes together, reconcile apparent inconsistency, and preserve coherence within the legal system. And this is consistent with the maxim or the presumption that Parliament does not intend to contradict itself. We made that presumption already. So it is the posture of the courts that statutes must be construed as forming part of a coherent legal system, not as isolated enactments. And if you remember, of course, Barak, his purposive approach, and also the teachings of Ronan Joachim, when it comes to the fact that the legal system is supposed to be as one coherent or underpinned by a certain values. Now, this issue of implied repealed often arise in subsidiary legislation. Maybe like we have some subsidiary delegated legislation and some other legislations or some other allies are also made later on. So in the event of a conflict between, let's say, two subsidiary legislation, the courts will have to determine which of the two has impliedly repealed the other. So for delegated legislation, it's very easy, but for parent legislation, the courts will often try to see if the harmonization principle that is trying to read all the statutes as together and try to get the interpretation which will cure the supposed inconsistency because of the presumption that Parliament does not intend to contradict itself. The court will always do that. It is only like, let's say, subsidiary legislation where the court will say that, okay, if we have a conflict between two subsidiary legislation, then one of them, of course, usually the later in term will be deemed to have repealed the earlier in term, as the case may be. Now, there's also some relationship with the Constitution. Implied repeal operate within ordinary legislation, but it does not apply to the Constitution. So within the doctrine of a constitutional supremacy, any inconsistent statute is void, not repealed. And this is so elementary that if you look at Article 1, 2, Article 2, anything which is inconsistent with the 1992 Constitution, to the extent of the inconsistency, is null and void. So this is nothing like repeal, no. So either if we have an inconsistency between two statutes, okay, implied repeal doctrine may apply in appropriate circumstances. If you have an inconsistency between a statute and a constitution, we have the principle of invalidity. It's not a repeal. So let's keep that in mind. So maybe one thing we should notice that implied repeal does not apply at large. There are some limitations. Implied repeal will not be inferred, where, for example, the earlier statute is special, and then the later one is general. So if the earlier statute, for example, is a very specific legislation or special legislation, and then the later statute is a general legislation, then you cannot invoke the implied repeal doctrine to say that because one is later in time is deemed to have repealed the earlier one. No, the later in time is a general legislation and this is a special legislation. And remember the specialibus non-derogat principle general. Yes. Again, implied repeal will not be inferred where both statutes can be reasonably harmonized, where you can do interpretation to cure the inconsistency or the supposed irreconcilability, then implied repeal doctrine will not apply. And then the implied repeal will not be inferred where inconsistency is only apparent. They're just on the face of it, but not rare. If it's not rare, if it does not really go to the root of it, it will not apply. Also, we have noted the special and the general statutes. And the point to note is that a general statute or legislation does not impliedly repeal specific statute unless clearly intended. And this is very important. So unless there's a specific mentioning in the general legislation, otherwise you cannot say that it has actually repealed a special legislation as it were. So let us keep that in mind. And then you read the case of Charles versus Attorney General. Do you remember? Do you read Charles against Attorney General? Very interesting case from your constitutional law case. Can you tell about Charles against Attorney General? Anybody? Yes. Are you familiar with that? Charles against Attorney General? Are you familiar with Charles against Attorney General?
My lord, I think it's about citizenship, but it's not.
You haven't read it yet.
My lord.
Yes, yes,
Yeah.
yes.
Yes.
So I think the case was about them taking a writ for a declaration that they were Ghanaian citizens and therefore entitled to operate a transport business. So there was an act that was passed which prohibits certain which reserves certain kind of job for Ghanaian citizens, and so which then means that if you are not a Ghanaian citizen, you can't operate such business. And they went to court for a declaration that they were holding a Ghanaian passport, therefore they are Ghanaian citizens and also have the right to operate that business.
Okay. All right. Thank you. That's a noble attempt. Yeah. So, if, as you rightly told us, that in Shalabi against Attorney General, the plaintiffs, one was born in 1933 and the other was born in the 1935, but their parents are Lebanese. And in July 1967, they were granted the Ghanaian citizenship under NLC Decree 191, that is the nationality decree at the time of 1967. And they had to renounce their previous British nationality. So later on, 1969, the provision of the NLC Decree 191 under which they got their citizenship was repealed. and substituted by a new paragraph of the new legislation, Ghana Nationality Amendment Decree, NLC Decree 333. Now, under the new paragraph, no person could acquire Ghanaian citizenship unless at least one of his parents or grandparents was born in Ghana. Mind you, these people, they were Lebanese. So under the old paragraph, the applicant for Ghanaian citizenship, like the citizens, like the plaintiffs, must merely show that they were born in Ghana before 6 March 1987. And on that day, they were citizens of the UK and colonies of British protected persons. Now, the issue was whether the new law, that is NLC Decree 333, which was deemed to come into effect on 25th July 1967, the same date, they backdated it. The original law, NLC Decree 191, came into effect on 25th July 1967. And this new law, NLC Decree 333, was also deemed to have come into effect on 25th July 1967, the same date as the NLC Decree 191. And it had the effect of divesting the plaintiffs of their Ghanaian citizenship acquired under NLC Decree 191. Because under the old law, it was not a requirement for you to prove that one of your parents, for example, should be a Ghanaian or of a Ghanaian descent. And that was why under the old NLC Decree 191, despite the fact that their both parents were Lebanese, they could still have a Ghanaian citizenship. But here, mind you, the new law, NLC Decree 333, has been backdated to have a retrospective effect from the same date on which the particular law that enabled them to acquire Ghanaian citizenship had actually come into effect. Now, eventually, when the matter came before court, the issue was whether NLC Decree 333, which was deemed to have come into effect on 25th July 1967, had the effect of divesting the plaintiff of their Ghanaian citizenship acquired under NLC Decree 191. And the court held that even though NLC Decree
Why
333
am I not seeing you?
was made to take the person whose hand is up, just a minute, let me finish talking about this case. Yeah. So the court held that in this Shalabi against the Attorney General that even though the NLC Decree 333 was made to take effect on the same date as the NLC Decree 191, that's the retrospective effect, it did not have the effect of depriving the plaintiffs of their Ghanaian citizenship acquired under NLC Decree 191. And then the court also held further that if the legislature, by enacting NLC Decree 333, had intended to deprive citizens or persons like the plaintiffs of their acquired citizenship, it should have stated that intention in explicit terms in the decree. And Justice Ivro Benjamin put it this way, quote, "Citizenship is not to be destroyed by inference. The inseparable result is that NLC Decree 191 was in existence and came into force before NLC Decree 333, and that the plaintiffs have acquired citizenship, right, and NLC Decree 191. The later decree, not having specifically divested those who acquired citizenship of their right, it is clear that they continue to enjoy those rights unless same has been specifically removed by subsequent legislation." Yeah, so the court was just trying to tell us that if you want to take away rights which have been accrued, it will have to be quite explicit. And you cannot just infer. You cannot just say that because you've made like a new law and you backdated it, things which had already been acquired under an earlier law, which you are seeking to repeal. By this new law that will migrated to the earlier law should actually be determined to have really stripped people of their accrued rights or interests. And I think the ex parte shall be is a very wise decision. Can anybody tell us what happened in the case of, I think the former president was a lawyer at the time, the Ghana Ports and Harbors Limited against Isufu. Ghana Ports and Harbors Authority against Isufu. Yes. What happened and what does it teach us about repeals? What do you call it? The Gapuha and the Isufu. Ghana Ports and Harbors Authority against Isufu. Yes. LSK, do you want to say something? You want to bless us with the Ghana Ports Authority against Isufu?
My lord, my hand had been, I had wanted to ask a question.
Okay.
So my question was, is in regards to in regards to the British Highways and the Attorney General, where the new law came into force and the court ruled differently. So I was just trying to juxtapose it with the case of Chachu Chikata. And I would just like to know how, if it's a good case to blend in terms of answering questions, because
So tell us what happened in Chachuchikata, an interpretive issue.
So I remember he was being charged for willfully causing financial loss to the state. And his argument was that at the time, whatever he did at the time that he's being charged for, now, at the time the events happened, there was no law like that. So a new law coming into force that introduced an offense of willfully causing financial loss to the state, if I remember correctly, is against the provisions of the Constitution. That's Article 19(5) or 7 or so. But I was trying to see how differently that one is from the British.
So let me, if you've read that case, let me ask you the alleged action or inaction or the alleged acts. When did they happen? And all the time, you should be interested in chronology when you are dealing with repeals and retrospective, retroactive legislation. So the alleged actions or inactions, when did they occur? The particular law under which he was being charged and tried, when was that law made? When did it come into effect? So those are the important inquiries who should be made. Once you make those inquiries, you can deal with all manner of scenarios. So yeah, so provide us with the information. The acts, when did those acts occur? And then the particular law, when did the law come into force?
My lord, I can't really remember correctly, but then if my memory serves me right, following the case, I think he said the event was in
hold
progress.
attention. We still have some few minutes. Look it up and then you come back with the information so that we discuss it. Okay.
Thank you, my lord.
Yeah. So I asked a question about the Kapuha and then Yusufu Kabore. Yes, Who will bless us with that case, or who will tell us about it? Mind you, this is supposed to be a tutorial, but I've turned it into a lecture, as it were.
My lord,
Gapoha and the Yusufu, yes.
I'll try and then give the facts.
Okay.
So, in the Gapoha case, back then, Ghana Ports Authority and then Ghana Cargo Holding, they were two separate entities that were in charge of exports and imports in Ghana. And Yusufu had an issue with these two parties who were the defendants. He sued both of them for some number of bags, missing bags of rice, I think 1,400 or something, imported to Tema Port. And both the defendants were denying liability. So during the subsistence of the suit, I think in 1980, PNDCL 160 repealed SMCD 96, which was governing Ghana Ports and Harbour Authority. And that PNDCL 160, which repealed SMCD 96, merged Ghana Ports and Harbour with the Ghana Cargo Holding and transferred assets. But that merger was silent on the liabilities. And then the suit proceeded against Ghana Ports and Harbour after the merger. So it was more or less like the law had, the new law had cancelled or scraped away the existing institution of those two bodies, made it one, but then didn't say anything in relation to the liabilities that would arise or that existed before the merger to make Ghana Ports and then Ghana Cargo Holding one. So I think, and I'm not too sure about the holding, but I think the Supreme Court held that the PNDCL 160's repeal of the SMCD, which was governing Ghana Ports Authority and merged Ghana Ports Authority to Ghana Cargo Holding, did not extinguish or exclude the merger of the creation of the Ghana Port and Harbour Authority's liabilities for predecessors, and that pre-repealed obligations and liabilities survived the repeal. So in that case, actions or pending actions continued as if no change had occurred, and that the silence on the liabilities meant automatic transfer, preventing injustice. I think that's what I remember on it.
Well, thank you. Yeah, and that is a good account. It's a short judgment, and it's a very beautiful judgment in the sense that the court actually goes to town to try and then give us a review of cases in which a similar incident came. So if you take so I'd like all of you to read it. So if you take the report, for example, the court will make the point, quote, the last ground which forced consideration this appeal is argument that the defendants are exempted from liability by virtue of PND's Law 160. That is the Ghana Ports and Harbours Authority Law 1986, which created the defendant authority. And the court continued. It was contended that even though Section 6 of the said law transferred access of the original two defendants, the Ghana Cargo Handling Company Limited and Ghana Ports Authority, to the present defendant, which is the one body now, the Ghana Ports and Harbours Authority, the law did not mention their liabilities. And because of this, cancel meant that any liability incurred by the original defendants in this matter cannot be responsibility of their successors. The defendants herein has no liability has been transferred by the said PNDC Law 160 to the defendant, as has been expressly done in the case of access of those original defendants. Now, this was the argument by counsel for the defendant, and counsel for the plaintiff disagreed. And his answer is that there's no express provision in PNDC Law 160. That is the law creating this new body, which is taking up the two previous bodies. prohibiting the discharge by the defendants of liabilities incurred by the original defendants, and that if any of such accrued rights were intended to be taken away from those who had acquired such rights, express provision will have been made for that purpose. To accept the interpretation being suggested by the defendant's counsel would, in the opinion of the plaintiff counsel, lead to an incongruous situation. So the court will review and eventually it will refer to the Section 8.1, which we discussed earlier on in the British Airways against Attorney General, and that Section 8.1 of the repealed CA4, that is the Old Interpretation Act. And then it will cite similar cases like the Sleeping against the Ghana Ports Authority, and the Sleeping against Ghana Ports Authority. The court, there was a High Court decision, made a point, just a short point, and this was it. I quote, the provision under Section 8.1 of Interpretation Act 1960 CA4, especially subsection 1C and E, had the effect of saving every liability which attached to the SY Ghana Railway and Ports Authority, created under the Railway and Ports Act 1971, and which was to be adjudicated upon, as well as right of any person in legal proceedings to recover any damages, compensation, that indeed might dispel the applicant's enchantment that the plaintiff action abated when the Ghana Railway Corporation Decree 1977 and Ghana Ports Decree 1977 came into force, unquote. This topic is very important for every student of the law and a lawyer. You need to understand, how repeals actually operate, its dynamics in the law. And that is why I want you to take reading of the cases serious. It's only when you read the cases before the principles that we are discussing, the section 34 and 35 of the New Interpretation Act will become meaningful to you. So having done that, the court will come to the first of the instant case, and that is the holding. And it's just the last paragraph of the judgment authored by, so quote, in the present case, the plaintiff action was pending at the court for about 5 years, as I've already said, before PNDC Law 160 was passed. There's nothing expressly stated in this law affecting this pending action. The liabilities of the original defendants have therefore not been excluded or extinguished by the coming into force of PNDC Law 160. The repeal of the Ghana Ports Authority Decree 1977, SMC Decree 96, and the creation of the present defendants, Ghana Ports and Harbours Authority, the successor of the original defendants. The defendant appellant cannot, in the circumstances, escape liability merely because it is not stated in this law that the liability of the original defendant should be taken over by the present defendants, the appellants. So the appellants have accordingly filed on this ground. So the court was saying that the mere fact that the new law creating this new body, which has taken over the previously two existing bodies, out of which the transaction we are talking about emanate, does not mean that liabilities which those bodies had will not be taken over by the new body. Of course, it makes sense. Otherwise, it will amount to the state using the law to shortchange citizens. You create a new body, and then you just remain silent regarding liabilities of the old bodies which are being taken over by the new body, and say that, well, because the law is silent, then the liabilities and debts of the old body, which is now being taken over by the new one, those liabilities cannot pass on to them just because the law is silent on that. That will actually not be good. And that is why the court rightly came to that decision in the Isifo Gabori against the Ghana Ports and Harbours Authority. So please read that decision once again. And I also like you to read the case of Coles Motors against the Checkpoint Ghana Limited. Coles Motors against the Checkpoint Ghana Limited. Or if you've read it and anybody will tell us, that will be appreciated. Okay, so let's say a few things about retrospective legislation. When we say retrospective, and sometimes we also say retroactive, retrospective and retroactive, do they mean the same thing? Yes. So a statute itself will be retrospective or retroactive, where it operates on past events, or it operates on existing rights or completed transactions. So in such a way as to alter the legal consequences. So that is what we mean by it being retrospective. And you've already mentioned the case of Ubon Tew against Kandarian Bas Mara, an English decision in which Lord Beham gave the famous dictum that a statute is retrospective if it takes away or impairs a vested right acquired under the existing law, or creates a new obligation, or imposes a new duty, or attaches a new liability in regard to events already past. And in terms of what constitutes retrospectivity, three essential elements emerge. One, we have impairment of a vested right. That is, a statute is retrospective if it divests rights already accrued, and then it also reduces or extinguishes existing entitlements. So that is one element of retrospectivity. For example, if you have a law that invalidates contracts already lawfully concluded, that will be trying to undermine vested rights. The second element of retrospectivity is the creation of a new obligation. So in that respect, a statute is retrospective where it imposes duties not existing at the time of the act. So if you have, for example, a law requiring compliance with a standard that did not exist when the act was done, then you are trying to create a new obligation which did not really exist at the time that the particular action was done. And then the third element of retrospectivity is the imposition of a new liabilities. If liabilities are tied to past conduct, for example, you impose penalty for acts that were lawful when performed. At the time that they were performed, it was lawful, but then you now make it unlawful as it were. Now, in terms of language, the word or the phrase retrospective law and then retroactive law, they are often used interchangeably. But if you analyze them, we will say that retrospective law affects legal consequences of past events. That is retrospective. And then retroactive law operates as if it existed in the past. So in terms of theoretical distinction, maybe that's what we can say, but except that in practice, oftentimes courts and lawyers treat both under the same doctrinal framework, as it were. But the point to also clarify is that a statute is not necessarily retrospective merely because it affects existing rights or it draws on antecedent facts. So let us keep that in mind, because a statute may rely on past facts without being truly retrospective. I think there is a case we call the Fenuku against Jointe. Is anybody familiar with that case? Yes.
My Lord, respectfully, this is not about the case. I'm just notifying you about the time.
Yeah, so you can go. I will keep teaching, but I'm recording it, so because I'm not teaching
Okay.
this again, so that we can play it back. Because
Okay,
today
sure.
is the last class, and you're writing your mock.
And we have another class
Yeah,
as
you're
well.
writing your mock when we come back. So when you are playing, I'll give some instruction on how to answer questions. So make sure that you play back that particular aspect. Because
Yes,
somebody asked a
please.
question as to how you should answer questions. Okay.
Yes, please. Thank you.
Yes. So if anybody can tell us about the Feneku and Jointe, that is if you are familiar. If you are not familiar, that is fine. You continue.
My Lord, I think that's, I just remember the main issue there, where property was acquired under joint tenancy, and then some years later, a law was passed that such acquisition would be where essentially turning it into tenancy in common as opposed to joint tenancy, and the question was about whether or not how the I think it was a man and wife, and how it would be interpreted now, given that at the time that the property was acquired, it was a joint tenancy as opposed to tenancy in common.
Okay. I would like you to pay. Thank you. I'd like you to read the judgment of Atukuba GSC. I think he dwelt a little bit more on the interpretation side. And also Pega, read Pega judgment. If you read the decision, for example, part of Justice Pega's judgment, he was trying to explore the effect of the section 14.3 of the conveyancing decree vis-a-vis the common law, as it were. And part of the judgment, he would make the statement that I quote, "It is a proposition familiar to all lawyers that where a statute is passed altering the law, unless the language expressly or by necessary implication indicates an intention to the contrary, the law is regarded as intended to apply to situations generated after commencement of the new statute. In other words, it must be applied prospectively." Then he cited the Husband's Laws of England, and he quoted a portion of it as follows, quote, "An amending enactment is generally presumed to change the relevant law only from the time of the enactment's commencement. In the absence of a clear indication of contrary intention in an amending enactment, the substantive rights of the parties to an action thus fall to be determined by law as it existed when the action was commenced. And this is so, whether the law is changed before the hearing of the case, at first instance, or while an appeal is pending. However, an amending enactment may say expressly or by implication that its effect is retrospective, unquote." Yeah, so having quoted this, he will discuss it extensively, and then he will ask the question, how relevant is this rule against retrospection? And that is where I want you to read the judgment and know. It's not a lengthy judgment, so I'm not going to tell you more about it. The aspect which relates to interpretation is very limited. So, for example, if we take his own judgment, the relevant part to interpretation, the retrospective aspect is just about 2 pages, okay? Just about 2 pages. So just go there and then read it to fill in the gap in the notes or the discussion. So does the statute change the legal consequences of those past facts? And that is what the Fenoku against John Tay will help us to understand. So go and read that. So as we have noted already, statutes are supposed to be what? Forward looking. That is a prospective. And we've also noted that when it comes to criminal law, it's even stricter. We saw British Airways against Attorney General, where we are told that prosecution cannot continue under repealed statute unless expressly preserved. And we've also quoted the section 107, and we have explained that to mean that substantive laws affecting rights and liability must operate prospectively, not what? Retrospectively. But there are exceptions, and the exceptions to the rule or the proposition that the law should be forward-looking will include procedural law, as we've noted that no one has a vested right in procedure, and that procedural laws apply immediately. So that is one exception. And another exception, of course, is still part of procedure when it comes to rules governing evidence, particularly evidential rules relating to proof, not rights. That one too, the principle of prospective effect does not really apply. And again, you also have a declaratory statutes. You have a statute which sometimes clarify existing law. It does not necessarily have to be prospective. It can also be retrospective, as it were. And in Ghana, we used to have those days, especially during the military regime, where they will pass a legislation and say that removal of avoidance, removal of doubt or avoidance of doubt, and then they pass a law just to achieve that. So that is a declaratory statute just to try and clarify the existing law. And that does not have to have a prospective effect. It can have a retrospective effect. So let's keep that in mind. And again, when we were learning about the presumption, all the things that we learn about presumption with respect to retrospectivity, please go back to the notes or your textbook references on the presumptions and read them, because they are very important and they apply to all that we are discussing. So let's keep that in mind. So as I said, I want to share a few thoughts on what you should do when you are dealing with the problem-based question. And the two groups which are here to present, I'm sure because you're going for a class, you will not be able to do that, but we still need to hear the response to the questions which were given. Now, for interpretation examination, you'll notice the questions are usually of two categories. We have a problem-based question, which oftentimes that will be in the majority, maybe just one or two essays, as the case may be. Now, one thing you should notice that interpretation question, of course, I'm dealing with the problem-based question. Interpretation, we are learning three things. Interpretation of non-statutory documents like these and other documents. We are also learning interpretation of statutes or legislation. I also learn interpretation of a national constitution. And for that matter, when you have a problem-based question, you must be structured. And first, you must identify the nature of the instrument. So what exactly am I interpreting? Is it the statute? Is it the constitution or non-statutory? So if it's a problem-based question, it is important for you to let us know that what the area of interpretation involved is maybe interpretation of statute, interpretation of national constitution, or interpretation of a non-statutory document, particularly let's say will, or particularly contract or other document, as the case may be. So you must tell us that that is important. That is important. And the reason for pointing that out is to guide you so that you will be careful what principles to set out and what principles you are going to use to do the actual interpretation. As we know, if you are dealing with the non-statutory document, there are certain things which are unique or peculiar to that, may not apply necessarily to, let's say, statutes and national constitution, and vice versa. And that is why we need to indicate as part of our introduction what exactly am I interpreting, what category is it, the statute, constitution, non-statutory document. So that is important. Then the next step is to identify the precise interpretation issue. So what is the interpretation issue? Which word, phrase, provision, or whatever? What is the interpretation issue or issues, as the case may be? Sometimes, as you will notice in the questions, competing interpretation might have been set out. Probably if it's, especially we are given either a scenario from proceedings in court where this lawyer has said this, that lawyer has said that, or sometimes, not even in court, some situation where rival interpretation are being set up with respect to the particular text being interpreted. So you must identify the competing interpretation, and either the student will have to appreciate the competing interpretation, for example, set up in the particular scenario, as the case may be. So, for example, if it is in reference to, let's say, proceedings in court, and counsel A has set up this, counsel B has set up that, you need to, demonstrate that you appreciate what is happening, and then you go to the next important one. You have to state the relevant rules of interpretation, and this is where most students fail. So here, you must select the core interpretive tools, and this is important aspect of the question. So, and that is why what we did in introduction becomes important. If you say that what is at stake is interpretation of a statute, and when you come to the relevant rules, they're going to tell us about the rules which relate to interpretation of statutes. And so question is, what should you say here? Must you talk about the literal rule? Must you talk about the golden rule, the mischief rule, the purposive approach, I still talk about the use them, generis, the linguistic, the is to interpretation, presumption, and so on. Well, what I would say is that it will depend very much upon what the question is saying. But since it's an examination, we need to be convinced that you actually know what we are talking about. If, for example, it's about statute, if it's about statute, it would be good for you to outline, the literal rule, the golden rule, the mischief rule, and then the purposive approach. And then you make the point that we have, aids to interpretation depending upon what is at stake. Both internal and external aids, and then including the linguistic, the canons. And of course, these are also supported by appropriate presumption. But here, we cannot be quite prescriptive in terms of the extent of what you should actually present, since there are a lot. It will depend very much upon the interpretive issues that you've identified. So that if the interpretive issues that you've identified, for example, there's nothing relevant about, let's say, presumption, or it's not going to feature so prominently, you don't need to tell us more about that. Or if there's nothing significant about, let's say, linguistic canons, you don't need to tell us anything about that. It will depend upon what you have. Now, if it's a non-statutory document, you need to always tell us. If, my lady used to say in the class that if you don't know anything at all, not the binding and binding, that interpretation, the intention of the maker or the testator is paramount. The four corners rules, the document must be read as a whole. An ordinary meaning is what will be sought after, unless we have a technical context, and so on. So you present, the statement of the relevant rules depending upon the category of the interpretive test. Now, in the same vein, if it is a constitution, if the interpretive test is like the national constitution, then you need to also tell us the rules. Of course, pretty straightforward. What we know, the broad liberal purposive approach, as we've discussed it, the letter and the spread, which you've talked about. So you have to tell us the applicable rules of interpretation in this case are, then you outline them, as it were, according to the particular type of interpretation that you are doing, or the category. Now, when you are done, you now come to the application. You have to apply the rules to the facts. And this is very important. So you must take each rule and apply it correctly, and concretely to the facts. And as you do it, sometimes depending upon what you're doing, it may be some relevant cases, for example, who supports a certain interpretation that you're making. I mean, you may have to illustrate that. Now, then another thing I should say, you may read the case and you notice that that case is actually adaptation. I mean, you may read the question, you may read the question in exams, and you notice that the question is an adaptation of a certain decided case. So what should you do? Should you just tell us straightly what happened in the case straight away? I would say no. You still have to be structured. You need to be systematic. Unless it is an essay question and then you are asked to, for example, discuss the particular case. But if it's a problem based, but then you read the problem and you say that, this case is an adaptation from Kapoha in Esifo, or adaptation from Shala Beavers Attorney General. adaptation from Barney and Barney or Achim across us to or whatever. So we just tell it, no, don't do that. So long as it is a problem based, we say how to be structured. It is only where it gets with application that may be you have to now cite and discuss that case to reinforce a particular interpretation that you are doing as a client. So let's keep that in mind. Of course, sometimes so, depending upon how the problem is, you may have to, if there are rival interpretations set up in the problem, after doing all that you have said, you may have to weigh the competing arguments, and then you use the law that you have stated to actually justify your preference for any of the rival, interpretation being put up in that particular scenario, as the case may be. So let's keep that in mind. And of course, you must always have like a conclusion, which is very important. Yeah, so any other question before we go? Okay, so I think after the Easter break, we take the two outstanding presentation. Then I'm also going to, give you more questions for you to work on them. Is my lady here? Okay.
Yeah, my lord, I'm here.
Okay. Yes, anything for your student?
Oh, nothing for today. Just to say
Okay.
hello to everybody and that we should learn hard and read all the cases.
Yes, very important.
And they shouldn't be fixated on knowing exactly the trend of the questions. It's just to know the substance and how to apply it.
Yes.
It'll be fine.
Yeah.
Thank you, my lord.
All right. Thank you.